After the death of the incapacitated person, can the guardian retain the guardianship assets to pay non-guardianship related debts? To find out, you have to read Matter of Shannon, but it's 6 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Shannon. The citation for this case is 25 New York 3rd 345, published by the New York Court of Appeals on June 10th of 2015. The issue in this case is whether a guardian for an incapacitated person after the death of the incapacitated person is allowed or authorized to retain assets of the guardianship to pay a claim unrelated to the guardianship itself. I'll explain that in a few moments. The background I think that's helpful to understand this case is it's important to know that MHL, Mental Hygiene Law, 8144, directs what a guardian must do after the death of an incapacitated person, their ward. 8144D says that within 150 days of the death of the IP, the incapacitated person, the guardian must, for relevant part here, deliver all of the guardianship assets to the representative of the estate or to the public administrator, basically to hand it off so that the surrogates proceeding can divvy up the estate as per either intestacy or according to the will, right? But there's a carve out in sub D that says you have to hand it over everything except for the stuff that's in sub E. And sub E says that the guardian is authorized to retain, pending settlement of the final account, the guardian can retain the property from the guardianship assets equal in value to the claims for administrative costs, liens, and debts. So D says you have to give over all the stuff to the next person in line for surrogates, but E says you can retain a certain amount of money to pay off administrative costs, liens, and debts. This case addresses what does that mean, administrative costs, liens, and debts. The facts here are that the IP here is named Edna Shannon, and Edna Shannon lived at Eastchester Rehabilitation Center, a skilled nursing facility starting in 2005. She was there for 3 years. So she's accruing bills at Eastchester Rehabilitation Center. Later on, she's found to be eligible for Medicaid under DSS. She applies for Medicaid in Westchester DSS, and they approve her for Medicaid. So she's now receiving Medicaid as of September 1st of 2008. And her guardian, she gets a guardian, which is Family Service Society of Yonkers. They're her guardian until she dies, they're her guardian until she dies. But at some point, Eastchester, she moves out of Eastchester to another facility in 2009, and at that point, Eastchester files a claim with the guardian saying, "Hey, before, just so you know, you owe us, the IP owes us $164,000 for services we rendered. $164,000. DSS then sees that people are filing claims, so they let the guardian know that they're owed about $166,000 too. By the time IP dies, by the time the incapacitated person dies, she owes about $200,000 both to DSS and to Eastchester. And at that point, the assets of the guardianship are about $190,000, not enough to satisfy all the debts. So here's the question. Does the guardian, within 150 days, she has to turn over the Family Service Society of Yonkers has to turn over all that stuff? And do they have to retain any property to pay off these claims or these debts to either DSS or Eastchester? The guardian files a motion to settle the final account, and she asks, what do I have to do here? And the Supreme Court at that point rules that the money should be paid, to the extent they can, to DSS to satisfy the Medicaid claims for all the medical care that's been given by Medicaid under Social Services Law 369-2, BIB. It gets appealed, and at the appellate division reverses and says, no, Eastchester filed first. I know Medicaid is a preferred creditor in that way, but Eastchester is the first to file. So their claim arose first, and because their claim arose during the life of the IP, DSS's claim only arose at the death of the IP. So for that reason, it should go to Eastchester. It gets appealed to the Court of Appeals, and here they decide the claim. They say the statutory language here is unclear. They say, first thing we look at is the statute. The statute's unclear. Administrative costs, liens, and debts. What does that mean? They ultimately say that the purpose should be found in the legislative notes. They look at the memo jacket for the statute 8144, and they say it's meant to reserve it's meant to retain a reserve to cover the reasonably anticipated administrative expenses related to the guardianship, not any other claim in the world. That's why you go to surrogate's court. So they say, therefore, they say MHL 8144 only allows a guardian to retain funds following the IP's death to pay claims related to the guardianship itself. Here, Eastchester's claim had nothing to do with the guardianship. In fact, a lot of it was before there was a guardianship. So that's got to be brought to the surrogate's court for resolution. The guardian cannot retain funds to pay non-guardianship related claims. That's the holding of Matter of Shannon. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.